Welcome to TriPoint Report, your trusted lens on immigration and global shifts immigration. The most urgent and underreported changes in U.S. immigration law in 2025. In today's fast-evolving immigration environment, staying informed isn't just helpful, it's absolutely essential. From new travel restrictions to heightened scrutiny at borders and prolonged application delays, immigrants in the U.S. are navigating a system that's becoming more unpredictable by the day. Whether you're on a visa, holding a green card, or sponsoring a family member, understanding the changes happening right now could protect your status, your future, and your freedom. This isn't about causing fear, it's about being ready. New travel restrictions stir confusion and fear. The White House is expected to implement new travel restrictions focused on specific countries, and the fallout is already being felt. Green card holders, visa holders, and even U.S. citizens are now questioning whether it's safe to travel abroad. The answer? No one knows the full extent of how far these restrictions will go. There are already verified reports of individuals being held at airports, interrogated for hours, and in some cases, denied reentry, even with valid immigration documents. What was once routine international travel now comes with serious uncertainty. Your digital life is no longer private at the border. Smartphones have become part of the immigration vetting process. Border agents can demand access to your phone without a warrant. That means your messages, photos, browser history, and even social media likes or comments can be used against you. This has especially impacted international students and green card holders who are now facing secondary inspections, visa cancellations, or denials of entry based on what they've posted or interacted with online. Lawyers are urging travelers to disable biometric features like Face ID or fingerprint unlock to protect against unauthorized access at the border. Aggressive vetting returns under the Trump administration. With President Trump back in office, immigration enforcement has shifted dramatically. Routine cases, such as U.S. citizens sponsoring their parents, are now being treated like high-risk applications. USCIS has reintroduced aggressive vetting procedures, which means longer interviews, in-depth background investigations, and unexpected arrests. ICE vehicles have been seen outside USCIS field offices. In some cases, applicants have been detained during what should be standard green card or citizenship interviews. What's more alarming, sponsors themselves are being investigated, especially for prior filings or alleged misrepresentation. Intentional slowdowns in immigration processing. Green card applications that once took a few months are now dragging out over a year. Family-based petitions, especially those in preference categories, are being delayed for months with no clear explanation. Waiver applications are stuck for years. Immigration experts believe these delays are not just administrative, they're strategic, designed to wear people down and force them to abandon their cases out of sheer exhaustion or financial stress. Filing early, submitting complete and accurate documentation, and working with legal professionals is becoming more important than ever. The return of the NTA policy. The Notice to Appear (NTA) policy is now fully back in effect. If your green card or immigration application is denied and you lack lawful status, USCIS can place you directly into deportation proceedings. That means even a minor error on your application, such as forgetting a required medical exam form, could result in your being summoned to immigration court. In some cases, ICE may detain individuals before they even have a chance to refile. The timeline to respond or appeal is tight, and the consequences of inaction are serious. To file now or wait? A big question many immigrants are facing is whether to file now or wait. For cases involving criminal records, prior visa issues, or complicated histories, speaking to an immigration lawyer is essential. In these scenarios, a waiver may be required, and the risks are higher. However, for most people, filing as soon as possible is the safer choice. Even having a pending application can offer a degree of protection, temporary status, and leverage if enforcement action is taken. In this climate, waiting can be dangerous. International travel. Think twice before you fly. Even for lawful permanent residents, international travel has become a source of anxiety. Many green card holders are hesitant to leave the U.S. out of fear they may not be allowed back in even with up-to-date documentation. The confusion is real, and many are turning to immigration attorneys before making any travel decisions. Experts are clear. If your green card is pending or your status is unresolved, avoid traveling unless absolutely necessary. Those with completed green card processes and no legal issues are still generally safe to travel, but they must be careful not to exceed the 12-month limit outside the U.S., or they could risk abandonment of status. An environment that demands caution and strategy. What's clear in 2025 is that immigration enforcement and policy are moving fast, and in many cases, under the radar. Changes are coming with little warning, and immigrants across all statuses are feeling the pressure. From airport detentions to digital inspections, from prolonged application delays to the threat of deportation for minor mistakes, this is not a year to be passive. Every decision, whether it's filing paperwork, traveling, or responding to a USCIS notice, must be approached with caution, precision, and ideally, legal guidance. The stakes have never been higher. The best thing you can do is stay informed, act strategically, and get help when needed.